I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this series on state public record laws and the Federal Freedom of Information Act. These lessons are brought to you by NEFAC with help from the Society of Professional Journalists Foundation, MuckRock, SPJ New England, and the New England Society of News Editors. Each lesson is a continuation of previous classes, so if you haven't already, please visit nefac.org/FOI guide. You'll find there a growing library of video tutorials and other freedom of information resources. Thank you again for joining us. Now here's NEFAC's Emily Sweeney to introduce you to our instructor.
Hey everybody, I'm Emily Sweeney from the Boston Globe, and I want to thank you all for joining us for this webinar, which is part of NEFAC's ongoing series on public records laws. And here with us for this session is Ray Marcaccio. He's the co-founder of Oliviero and Marcaccio, LLP, and he represents local news media organizations and brings claims for access to public records in court and government proceedings. So he has lots of expertise in this area. Ray, thank you so much for leading this session.
Glad to be here. Hi, everybody. I'm going to just spend a few minutes going over what your rights would be after you get a denial, and then if you have any questions on the practical aspects of it, I'd be happy to help out with that. So again, we're at the point now where the public entity, the agency, has provided you or should have provided you with a response. And either it's facially deficient or it's substantively deficient. So let's just look at what would be a facial deficiency and what would be a facial challenge. So it's when you look at it, either the response is untimely. So by statute, they have that 10 business days to provide you with the response. Or if they have sought in a timely fashion an extension, they get up to another 20 business days to respond. And the reasons that they are denying the request are in writing. Now, bear in mind that if any of those are missed, the timing is critical. So if they give you an explanation, but it's well after the deadline, the statute reads and is interpreted to mean that such a denial is waived. So even if they had a good justification initially, if they don't provide it in a timely fashion, it's deemed waived. So looking at it again, facially, is it in writing? Did they specify the reasons for the denial? And did they also specify the procedure for you to appeal their determination? Now, you may actually get some documents, or you may get a facially sufficient response. It's been timely, it explains why it's been denied. Then you should consider a substantive challenge as to whether or not you should appeal this. And in that case, you have an agency that's used one of the many exemptions from a document being turned over under 3822. So under Title 38, Chapter 2, there are a number, I think close to 30 at this point, of documents that can be excluded from being provided, even though they would normally be considered public. And even if they satisfy everything facially and you've gotten this response and it's timely, you should consider whether you should test that stated reason. So an example of that would be sometimes a public body can say that under 3822, the document is not being provided, even though it exists, because it's either a preliminary draft or it's a memorandum that would be confidential, for example, if it came from an attorney to the staff or attorney to the public body. But you know, if you're monitoring this agency that you've made the request, you probably have been involved in going to the meetings or looking at the minutes, and you could find out if, for example, when you look at like a preliminary draft, has somebody from the staff been presenting that quote preliminary draft to the public body in a public meeting, and the public body discusses it and talks about it. If that occurs, you have a basis to appeal that and say that, Well, while it might be a preliminary draft, it hasn't been, quote, finalized and would normally be accepted. It's been discussed in an open meeting. Another example might be if a lawyer provides a legal opinion to the public body, and normally that would be an attorney-client privilege. But that opinion, that memo from the lawyer is discussed in an open session. Again, if that happens, then you have a waiver of that normally accepted document. So that would be another reason to consider an appeal. And then the third area that you would normally be looking at for considering an appeal is if simply the agency has come back and said, yes, the documents exist. No, there are no exceptions, but it's going to cost several $100s. It's going to cost $1,000 to get everything copied, retrieval, going through old records to get them. And that might also be a basis for you to consider an appeal, because as the statute says, and I have quoted here, courts may waive or reduce the fees for search and retrieval if the documents are likely to contribute significantly to public understanding of the operations or activities of the government. I mean, that's a pretty big exception. And there's not a lot of case law. There's some case law on it, but not a lot, where you could challenge a cost that is being shifted to you and argue that the information that you're seeking would be of significant importance to the public to understand how the government operates. So that's also something that would be a consideration. So your analysis, when you get whatever response you're going to get from the agency, you've got to analyze and decide, is this even worth considering an appeal? And if you decide that it is for any of the reasons we just spoke about, then you would go to the next step, which is, how do you appeal that decision? And you have two courses of action. There's an administrative appeal, or you can go to the Superior Court. Most times, I imagine you're going to go the administrative route just for one, timeliness, and two, for the costs involved. So on that, on the appeal through an agency, and I should say this, whether you are appealing to the Superior Court or you're going to go the administrative route, either way, the starting point is the same, and that's what we're looking at right here. So after you get that adverse decision, they haven't given you the documents, or the documents they provided are insufficient, or they've relied upon an exception that you think is invalid. Whatever it is, your first step is going to be to petition within the agency. So you petition to the chief administrative officer of that public body. Now, I can imagine that for most agencies, you would expect to get the very same decision by the chief administrative officer as you would from that initial determination. It's even possible that at some point, the chief administrative officer became aware of your request, may have even spoken to staff about it. But nonetheless, you've got to go through this step in order to perfect your right to continue with any of the appeal process. So it's critical. And when you do it, when you file your request, the administrative officer has up to 10 business days to make a determination as to whether the initial ruling by that agency was right or wrong. Now, it's interesting, the statute doesn't give you a deadline for making that appeal, but it does give that deadline for the chief administrative officer. Obviously, for practical reasons, you want to get that done as quickly as possible. I'm sure if you're working on a story, 10 days would never even come into play. You'd always be getting it out as soon as you can. That request should be, when you're requesting that appeal internally, it should be in writing. And at this point, you should start to think about who your audience is. Now, admittedly, this first level is going to stay within the organization. But when you write this appeal within the organization, you should write it in a way thinking that and bearing in mind that it's quite possible that a Superior Court judge might be reading that someday as well, or that an Assistant Attorney General might be reviewing that as well. So now you're at the point where you should be more careful with your explanation as to why you should be obtaining that information. So whether you want to bypass the Attorney General and go to the Superior Court or go to the Attorney General, either way, this is the door. This is what the door you have to open so that you satisfy the administrative prerequisite of making the internal request. Once that's been done, once you get another denial by the agency at the next level, the final level within the agency, now you have to decide, do you go to the Attorney General or do you go to the Superior Court? And they're not mutually exclusive. So you can go to both. And again, from my own experience, it seems that in most cases, you're going to go to the Attorney General first. When you do that, you have to file a complaint. Now, to my knowledge, the AG does not have a form that you file. The AG does have certain forms regarding the Access to Public Records Act, but from my review of the website, at least, I haven't seen a complaint format that the AG uses. Instead, what the AG instructs you to do is to specify as best you can, one, what was requested, and two, the basis for the denial by the agency. Then you would explain why those reasons provided by the agency are insufficient. So you would go through, for example, under 3822, where you have like 30 different exceptions and they've relied upon an exception. It's something that's for a product. If you can then explain that, yes, but I witnessed and observed an open meeting where that document was actually reviewed, discussed, that body actually voted with that in hand, you're gonna have a pretty good chance of winning on your appeal. So, you know, again, at this level, whether it ends with the Attorney General or someday goes to the court, you want to be as specific as possible, include as many facts as you can in support of your position. You file it, and then the agency will have an opportunity, usually 10 to 20 days, to respond to your complaint. And then, from my experience, the AG can handle this in one of two ways. Sometimes you get a letter from the AG telling one side or the other that you asking you to show cause, basically, why that appeal should not be summarily denied. So that something about the decision by the agency is so bulletproof that the AG is saying to the requester, you know, explain to me why this shouldn't just be summarily dismissed. By the same token, I've seen them do the same thing to an agency and say, explain why this should not be granted. And so almost like putting the burden on one side or the other. Now, that doesn't always take place. Sometimes it does, sometimes it doesn't. A lot of times the AG is just going to send out a letter to both sides explaining, put in your position, and we will then make a decision. Under the statute, the AG really doesn't have a deadline to respond to your request. From my experience, it seems like it can be a matter of weeks. It can be a matter of several months before they even get back to you. But, and I, candidly, it seems like some attorneys general are more receptive to this statutory framework and the motive or the General Assembly's intention for having this law than others. I mean, it seems that you probably have more experience with that than I do in some cases. But, from my own observations, it seems like this Attorney General is very receptive to trying to get documents out to the public. And so that's something that bears, giving weight to as to whether you go to the court or to the Attorney General. At this point, with this Attorney General, you, I think, have a pretty fair shot at getting things released if there is a basis for it. And if so, you'll probably get a pretty good written decision. And if you get a really good decision in writing, that's going to be a precedent that the Attorney General will use in the future. So it all lines up in favor of making a good effort in writing. And if you have a receptive audience, a receptive office holder, it's that should be weighed into the equation as to whether you want to put in that time. So here, once the AG has completed the investigation, the complaint, you're going to get the letter either saying that the basis for the denial was justified or the basis wasn't. Obviously, if it's been justified, the AG closes out the file. If the AG affirms your position, then he's going to send out a letter to the agency saying you need to provide this information. And he may even need to file a lawsuit to get that done. Not usually necessary, but he has that authority. So he could seek injunctive relief. Injunctive relief under the statute is just asking the court to exercise its equitable remedies, its ability to order, to compel someone to do something, to enjoin them, to order them. And there they will be enjoining that agency to release the documents or some other declaratory relief. So that would be the Attorney General course of action. And of course, there's the other. You can go right after you get the denial from the highest level within the agency. You could then bypass the Attorney General if you wanted and go directly to Superior Court. Now, there are costs involved, I can imagine. I'm sure there'll be a lot of discussions with your editors as to whether or not this should be done. And you have to bear in mind that who's going to be the plaintiff? I mean, if you're going to be filing pro se as a reporter, you can do so. If you want to bring this on behalf of your organization, you can't represent anyone but yourself. You can't represent a corporate entity or some other person. So that would then trigger the need to get an attorney involved. So really, in most cases, I would think that you as a reporter will be seeking this on a quote pro se basis, where you yourself will bring the claim. I'm sure there are cases where you'll get the staff or the editors to agree that it's of such importance that it'll require getting legal counsel, getting the case filed that way, and bringing in either the corporate entity or in the name of the organization itself. The other thing I want to have you bear in mind is that there really are some advantages to the Superior Court. Like I said, some attorneys general are more receptive to the act than others. And I think this particular one is very receptive to and wants to help with this as much as possible. Others are not, going to discard it by any means, but they just may not have the same level of interest. But under the statute, the burden here is pretty interesting. Normally you go into a civil case and everybody's on the same footing. But the General Assembly has changed the burden in these cases in favor of the moving party. So you as a requester have a favorable burden of proof. And just quoting from the statute, it says, the burden shall be on the public body to demonstrate that the record in dispute can be properly withheld from public inspection. So that's a pretty interesting shift. You're not going in on equal footing. Actually, it's the agency that needs, in the first instance, to explain why it is entitled to rely upon an exception. Because the presumption is that the government record will be deemed to be public. That's a pretty good fact or position that we have, a legal position that we have through this statute. And while normally a case that I might get involved in, a regular civil case, can go on for years, 4, 5 years would not be out of the question. Under the statute, there is a right to acceleration. You as a plaintiff, and frankly, even the agency, can go to court and move to accelerate the hearing so that you get an expedited decision. And I've seen that done. Likewise, if nobody does that, the court itself might do that. So if, for example, you're on a motion, the motion judge might look at this and say, well, look, isn't this just under APRA, the public records request? I'm going to accelerate this. I want to hear this as to why it shouldn't be accelerated under the statute. So you could, unlike a regular lawsuit, where you might be waiting years for a decision, it's quite possible that you could get a decision within 3 months or up to 12 months. But if it's in that range of 3, 4, 5 months, that's not very different than what you're going to be encountering with the Attorney General, just given how much that the AG has to do on these cases. So that's another thing to at least factor in when you're trying to decide where to go with your case. Likewise, if you file in court, the agency should at least have more concern with the way that it has made its decision. The remedies can be severe. So they can be up to $2,000 for a knowing and willful violation. So if you can show that it was, an intentional, willful denial of something they knew should have been disclosed, you could be looking at a remedy of $2,000. That's important because under the statute, that remedy can be imposed not only on the agency, but on an official of the agency. And that's something that might give concern to the agency if you file that suit and might change their position from denying the request over to getting you the documentation. That's not common to expose a public body official to liability. And that liability would be personal. They would have to pay that amount of money because it would be a willful violation. Then there's a lower violation as well of $1,000. That's for a reckless disregard against the public body itself. So it's something where it isn't as intentional, but it's still reckless. And then that will be imposed just on the public body, not on the individual members of the body itself. But those kind of sticks that exist in the statute are things that the solicitor or the lawyer who represents the agency will be aware of and will start to factor in as to whether or not its initial denial is really worth defending, or if they should compromise that in order to avoid any bad facts that might show that they either didn't make that decision properly or even worse. And then the last thing here is just a cost-benefit analysis. So you have to decide whether the cost of filing that suit is worth it or not. And admittedly, it'll be more of an expense than just going to the Attorney General. But you could get fees. That's possible. One of the remedies might actually be fees under the statute. You could get an award of some other penalty. So those are the kind of things that, if it's a significant enough request, if there's enough in the balance on getting those records, I know a lot of us, a lot of you, kind of put the Superior Court action aside and say, yeah, we just can't get a lawyer. But it is definitely worth going through that analysis to see if it's something to be done, because you may get a more of a favorable outcome by doing it that way. So that's kind of the quick summary of the law and your options with that.
So we have two questions, I believe. Henry Hank Jones, he says, how about threatening or sicking an investigative reporter on a recalcitrant agency? I mean, I guess that could never hurt, right?
Yeah.
I don't know.
I think that's more of a staff decision than, legal, but yes. Yeah, I mean, being more aggressive. I mean, maybe along those lines of what Hank is saying. I mean, if you start to file, so putting aside that of just having, somebody just dog the agency, but along those lines, if you start to file 1, 2, 3 appeals to the Attorney General, or even one to the Superior Court, that's something that the agency will bear in mind the next time that it makes a decision about you. Because either it won before the Attorney General, but even if it won, it had to go through quite an ordeal to get to that point, and it knew that it might not succeed. And there might be something in the AG's opinion letter that gives it a warning. So, whether it's being more dogged about pursuing people at the agency itself, and that's something that you would decide as a staff, or going after this agency with 1, 2, 3, a number of requests to the AG, one after another, however long it takes to get them to be more faithful to the requirements of the statute.
And we have a few more questions. So Tim White was asking, he said, thank you. And he said, we skip the initial appeal to the chief admin officer of an agency and go straight to the AG. Is there any disadvantage to that?
Well, I suppose, Tim, if you went to the Superior Court, you could get a defense of the failure to exhaust administrative remedies. So if I were the lawyer for the agency, I would argue that you didn't even exhaust what you were supposed to do initially by going to the agency itself. I imagine the AG is not going to be as concerned about that because the AG wants to get to these issues. So that's the only real disadvantage to that I can think of. By skipping the internal process, there were two things. One, you lose that bite at the apple where at least you give somebody else within the organization a chance to correct what was not done. And two, there is that doctrine of exhaustion of administrative remedies. And Tim, I don't know where you are in your legal career. I think you're kind of about to be a licensed attorney, but I'm sure you've come across that even in some cases on the need to go through the administrative process.
And we have another question as well, this one from Jeremy Bernfeld. He asks, is there any requirement for a public body to delineate how many responsive records they've found when they deny your request? And do they have to give you any information about the responsive records, even if they claim they're all exempt?
Yes. So, I mean, obviously, if they say they don't exist, then the answer is 0. If they say that they have documents that exist, but are somehow covered by one of the 20, 25 plus exceptions, you're entitled to a privilege log. So the Vaughan Index, you're entitled to an index of the documents, likely would include information such as the name of the sender, the name of the recipient, the summary of what it was, and then the reason why it's not being provided. Now, the descriptions are pretty limited on that. They can be fairly cryptic, but it should be enough. It has to be enough so that you can be able to analyze the basis upon which they're making the denial. So if there's a memo from Ray Mercaccio to Tim White as the chairman of the board, and I'm not producing that, but it exists and it's otherwise responsive, I'm supposed to, as the agency, identify the document, the date Ray Mercaccio wrote it, who the recipient was, and how many documents it is. Is it 1? Is it 5 pages? Something that will give you a little bit more detail.
Great presentation. Thank you so much
Sure.
for going over the appeals process in Rhode Island. And I want to thank everybody. We've got a great crowd here tonight for tuning in, and be sure to check out our previous episodes on the NEFAC website and YouTube channel. So again, thank you, everybody. Thanks, Ray.
My pleasure.
Appreciate it.
Bye, everybody. Good luck.